Hey guys, welcome to another case decision. My name is John Watts. In this video, we're going to cover the Chiang versus Verizon New England Inc. case from the First Circuit Court of Appeals 2010. It's a Fair Credit Reporting Act. It has a little discussion of the FDCPA, the Fair Debt Collection Practices Act, but mainly it's Fair Credit Reporting Act. And this is a little bit older decision, but a lot of newer decisions cite to this, and so I want to show this to you. Now, those of you that are familiar with our channel, you know why we do this, because we can talk about what we think the law is. We can even look at the statute and kind of break it down. I've done all those. But the reality is, what do the men and women in black robes say? And even if we disagree with them, we need to know what they say so that we can argue in the next case to be able to persuade them to correct an error. So this case came out 2010, and we'll go through it. It's a little bit of a lengthy decision, so if you're looking for a 5-minute video, this is not the video. We'll go through this in pretty good depth, but it has a very nice discussion about the obligation of a furnisher. So a furnisher is like Verizon. They furnish information to the credit bureaus. And what happens when we dispute to the credit bureaus, Equifax, Experian, TransUnion, and then they notify a furnisher like Verizon? What's Verizon's obligation here? What do they have to do? So this whole thing has the consumer, and he is upset with Verizon. And he ends up having, I think, 2 state court lawsuits. And he's saying they bill me for stuff I didn't know. They continue the billing after I cancel my service, all sorts of stuff. And so ultimately he stopped paying. And so we have here that he sues Verizon in federal court seeking more than $1 million. And the district court, which is a trial court in federal court, granted summary judgment and threw out all of his claims, and then he appeals. And so what's the basis of it? So he says, Verizon, a furnisher of information, failed to adequately investigate disputes about the furnished information reported to it by consumer reporting agencies as required under the Fair Credit Reporting Act. And then he also says that Verizon was a debt collector and violated the FDCPA, Fair Debt Collection Practices Act. And creditors are not covered by that, but if they use a different name that suggests that they're actually a third party, a collection agency, then they can be covered under the FDCPA. So that's what he argues. And the court notes that there are some issues of first impression. That means this court, the First Circuit Court of Appeals, has not considered some of these issues. So let's look and see what they are. Is there a private right of action under Section 1681S-2B? And what that means is when you make a dispute to the credit bureaus and then they notify the furnisher and the furnisher does not do a proper investigation, can you sue the furnisher? And the court says, yes, we agree, and we're going to give you the standards or the rules involved in that. And they just say, yes, there is a private cause of action. In other words, you can file a lawsuit. The investigation must be reasonable. The test is objective, and the plaintiff bears the burden of proof that the investigation was not done reasonably. Another way to say it is that the investigation was done in a negligent or careless manner. And then they go on to say, requires plaintiff to show actual inaccuracies that the furnisher's objectively reasonable investigation would have been able to discover. And then they reject one of the defendant's arguments that references the earlier subsection, which precludes reliance on plaintiff's allegations. And the court says, yeah, that has to do with that other subsection. So the other subsection is you can dispute directly to the furnisher, and they have obligations, but you can't sue over that. And so it's kind of a meaningless provision, although we'll talk about how we kind of get around that to make the furnisher really have to investigate. And if they don't, then we sue them. And it involves notifying the furnisher directly and the credit reporting agency. So they say we affirm summary judgment because there's no genuine issue of material fact. And remember, summary judgment from other videos is where The court looks at all the evidence, so not just allegations, but the actual evidence, and says, is this in such conflict that either the judge, if there's no jury, or the jury has to decide who's right, who's wrong. The classic would be, I'm driving a car, you're driving a car, we crash in the middle of the intersection. I say I had the green light, you say you had the green light. Well, the jury's going to have to decide who had the green light. So the summary judgment would not be appropriate there. And they say there's two issues here that he bears the burden on. Number one, that Verizon's investigation was unreasonable, and that number two, there were actual inconsistencies. And then they also say, look, Verizon was not a debt collector. So we're not going to cover a whole lot of this, and the court even mentions that his disagreements with Verizon are not at issue in this case as far as the merits, and those have already been resolved. And actually, he basically lost those claims, which if you lose in state court, it'd be pretty unusual that you can then do a dispute and sue in federal court. But this is a construction, painting company. There's arguments over a couple of Verizon lines. And we're just going to skip over most of these other facts here. And let's go down to here. Suspended his account. It restored some service. He then filed a second lawsuit, and they were resolved primarily in favor of Verizon. So what are his claims? He's got an FDCPA, so Fair Debt Collection Practices Act claim, and he says they were a debt collector, and their practices were abusive, and they attempted to collect their own debts under names suggested debts were being collected by a third party. And so this kind of boils down to he had some information that there was a Verizon Massachusetts, and so he thought that was an independent company. So the court's going to at the very end come back to that, but we're not really going to focus on that. They just say no, it's same company, and there's no FDCPA liability. So the Fair Credit Reporting Act, which is really why I want us to look at this. So it says, in addition to letters from debt collection agencies, he received communications from the credit reporting agencies, including Equifax and TransUnion, reflecting his delinquent accounts. So he sent letters to the CRAs, and he said, remove it. And it says 8 of his demand letters were in evidence before the district court. And then the court says something that will seem a little odd, and we'll explore this and understand what the court's saying here. The FCRA claim against Verizon is not and cannot be based on what he told the CRAs. The claim is instead based on the communications from the CRAs to the furnisher and then the furnisher's response. So what they're saying is all we look at is, let me do it this way. So here you are. You're the consumer. Here's the credit reporting agency. You send a dispute to the credit reporting agency. Well, what do they do with it? They could resolve it on their own, but normally they then notify a furnisher, and that would be Verizon here. And then furnisher responds back to them, and then they respond back to you. So the court's saying, really all that matters is not even what you told Equifax or TransUnion, but what the credit reporting agency told the furnisher. And then what the furnisher did with that. That ought to trigger some thoughts in your mind that, well, wait a minute, I can't control what the credit reporting agency is going to tell the furnisher. So how do I make sure all my information in my dispute gets in front of the furnisher? Well, you send the copy of the letter, all the materials directly to the furnisher as well as to the credit reporting agency. And we'll talk about that a little bit more. All right, so let's see here. We get to the end of this long sentence. The evidence about the CRA's communication with the furnisher and the furnisher's response did not come from the consumer, but from the furnisher. And they had, and this is important, undisputed evidence. Okay. And for some reason, I'm not sure why, it doesn't appear there were any depositions taken. It doesn't appear the consumer reached out and got information, what we call discovery, from Verizon. Doesn't appear there were subpoenas issued to the credit bureaus, that the credit bureaus were sued. And so really all that the court has is what Verizon says. And shockingly, Verizon, the furnisher, says, hey, we did everything right. So Verizon uses this company, and sometimes we see this, Credit Bureau Collection Services, Inc., CBCS. And basically they've outsourced the putting stuff on credit reports and investigating disputes to the CBCS. And they admit that if CBCS violated the law, then Verizon violated the law. So the CBCS, responsible for initially transmitting consumer credit information to the CRAs, and then there's an online reporting system when the consumer disputes his credit report. Give me just one moment here. So the CRAs will notify CBCS when there's a dispute, and that triggers the protection of the 1681 S2B. And then CBCS investigates the consumer disputes by basically logging into Verizon's computer systems to determine the accuracy. And if CBCS has questions, then they contact Verizon. So CBCS received 12 inquiries from the credit bureaus over 6 months. So the consumer is doing multiple disputes here, which normally is a good thing. And he's questioning the accuracy. And this is important because, again, this will tell us why, not always, but usually we want to not only go to the credit bureaus, but also go to the furnisher with the information. I like to keep things simple. I just prepare one letter. It's got every credit bureau and every furnisher that we're challenging. They all go out by certified mail. Okay, but let's look and see. The record contains 12 summary reports recovered from the CBCS system. And so here are the disputes. Here's how they were described by the credit reporting agencies. Claims inaccurate information, paid original creditor before collection status, paid before charge-off, disputes the account, never late, it was paid, involved in litigation, and the consumer does not dispute these issues. And it says, although none of them had been made when he first filed his federal lawsuit. And then there's basically nothing else that happened other than after CBCS completed the investigation, they then responded to the credit reporting agencies and said everything is accurate. All right, so now the court's going to give us a little bit of procedural background. So in November, he files this lawsuit seeking damages, and we'll cover the footnotes at the end of this, and you'll see the pretty large sums of money that he was claiming. And then about, a little over 2 years later, the court granted summary judgment. And here's what the court said. The district court said that he had the burden to identify affirmatively information that a furnisher of credit information could have uncovered through a reasonable investigation. And then the district court said the First Circuit had recently issued a decision against TransUnion. Court noted Circuit recently announced similar rule in context of CRA's duty to reinvestigate information disputed by under the FCRA. Whenever you dispute, it's called a reinvestigation. Kind of skips the first investigation, but that's just the technical name. When you dispute, even if it's the very first time, they call that a reinvestigation. So the court said, let me just highlight all this here. Absent any corroborating evidence, allegations of inaccuracies were insufficient to demonstrate information might be uncovered, and it declined to consider his deposition testimony, affidavits, or demand letters in deciding whether he had demonstrated actual inaccuracies. So, really key point, this has to be actual inaccuracies. And it needs to be something that we can prove. Now, I will say this. It's kind of hard to prove a negative, okay? In identity theft, we are basing it on our word, okay? We raise our hand, swear under oath, it's not me. We go get a police report, and the credit bureaus better accept that. I mean, I'll just tell you this. It's very rare to ever get a chance to litigate an identity theft case, because whenever we dispute that, it goes away immediately because they're terrified of that. But what the court's saying is exclude that type of thing. You have to show the inaccuracy. So if I'm saying that I was never late with Discover, and they say I was late in January. Well, then I need to provide some proof of that. Do I have a bank account that shows the money coming out? Did I send my payment online and I got a receipt back? Did I do certified mail? I mean, what is it that I have to show that it is inaccurate? I can't just say, oh yeah, I paid it on time. I mean, this is what debt collectors do when they sue us, is they'll say there's statute of limitation issue. They'll say, oh, well, you made a payment right before enough years ago that we just filed the suit in time. And we go, well, show us proof of that. They go, oh, well, we don't have it. You must have paid cash. I mean, no, you got to come up with something. So that's what the court's saying here. All right, so there are some questions of law, and the court notes that because these are questions of law, the review is what's called de novo. In other words, they don't particularly care. That's probably not the right way to say it, but they're not bound by what the district court did. Now, if the district court had conducted a trial and decided, remember my example of who had the green light, I say I had the green light, you say you had the green light. Well, the appellate court's very reluctant to disturb the finder of fact, the judge or the jury who weighs the credibility. But here, it's just legal questions. And then we'll go here to the first point. And they say, there is a private cause of action, so you can sue furnishers under the FCRA, and the breach of the duty to investigate is evaluated under an objective reasonableness standard. Now, in 2010, and when this case was filed in 2006, most courts understood that you could bring a lawsuit. But occasionally, and back in this time period, we started getting people saying, well, wait a minute, there is no private right of action. There's this crazy decision out of Tennessee that they love to cite, and they would ignore the 50 cases that rule the other way. So this is not an issue anymore, but it's important to see what the court says here. And they say, we quickly dispose of the question whether there's private cause of action under 1681 S2B as the question is related to our jurisdiction. And the court notes what Congress did. We've got this law, the FCRA in 1970, to ensure fair and accurate credit reporting, promote efficiency in the banking system, protect consumer privacy. And so the FCRA imposes obligations on the CRAs and users, that would be somebody that pulls our credit report, users of information, and provides for enforcement by various federal agencies. Act also expressly creates a private cause of action enabling consumer suits for willful, that would be intentional or reckless, or negligence non-compliance with its requirements. What do you get? Well, you get actual damages for negligent violation and actual or statutory and punitive damages for willful ones. And they say there's no basis for any claim of willful violations on the record, so only actual damages are at issue. I would disagree with that. If there were 12 disputes, spread out over some different credit bureaus, that is enough to get willful. But the court's correct in that it doesn't matter, because ultimately they ruled that the investigation was not negligent. Well, if it's not negligent, it certainly is not willful. But this statement that there's no basis for any claim willful violation, that's just not correct. So in 96, we have a change here. And let me just get this highlighted. So substantially amended the FCRA. Those amendments are involved here. A new section governing the responsibilities of so-called furnishers of information to CRAs. This addition was intended to close an identified gap in the coverage where even dutiful or proper or reasonable investigations of consumer disputes by the credit reporting agencies could be frustrated by the furnisher's irresponsible verification of inaccurate information without any consequence to the furnishers. So before 96, you could dispute, and the credit bureaus go to the furnisher, and the furnisher goes, yeah, we know it's wrong, but so what? We're going to verify. Well, this is now saying to furnishers, if you verify stuff that is incorrect and you were negligent in doing that, you have problems. So this is, it gets a little complicated because this statute's been changed, and it's a pretty long statute, but Under 1681 S2, furnishers may not provide inaccurate information, and they have duties in the event of a dispute. But here's the problem. This one right here, you can't sue for. So it's very frustrating. And people still come to us, lawyers come to us and say, hey, they're submitting false information to the credit bureaus. There's a law that says they can't do that. I want to sue them. And we go, yeah, but you can't. The law's there, but you can't do anything about it. But the 1681 S2B, you can. So only the second of these duties is subject to private cause of action. His appeal concerns the latter obligation, the furnisher's investigation into disputed information. To understand his argument, we outline both provisions. So here we have that subsection A. So it prohibits, that's good, it prohibits any person from furnishing any information relating to a consumer to any consumer reporting agency if the person knows or has reasonable cause to believe the information is inaccurate. So you see the theme throughout the FCRA is accuracy. It's got to be accurate. And if it's not accurate, sorry, I don't know why I just activated Siri there. But the point is that it's got to be accurate, which means you can dispute inaccurate information. So that's this section 1681 S2A1A. Congress limited their liability by prohibiting private suits for violations of that portion of the statute. But what about this other portion, the 1681 S2B? It outlines a furnisher's duties when a consumer disputes the completeness or accuracy of information in the credit report. So, consumers notify the CRAs of the disputes, and it says, although a consumer may dispute credit information directly to a furnisher, and it says that he has done that, the consumer has no private right of action if the furnisher does not reasonably investigate the consumer's claim after direct notification. And that's true, except if you notify the furnisher directly and the CRA notifies the furnisher of your dispute, then most courts say that furnisher has to use all the information it has. And this is why we often copy the furnisher on our disputes, because we may send 5 pieces of evidence to the credit reporting agency, but what if they just call it one thing and send that to the furnisher? Well, we want the furnisher to also have those 5 pieces of information. So you kind of have to put all this together and to understand how to do this. So when a consumer disputes credit information to the CRA must advise the furnisher of the data dispute exists and provide the furnisher with all relevant information. Now, let's think about this. If you submit a bunch of information to the CRAs and they don't supply that, well, then it would seem that they haven't done a proper investigation. This is also why we don't like online disputes, because they try to pigeonhole you into, you select a little button like, radio buttons, and you pick one and say, not mine, or never late. And they generally make it difficult to submit information. Say you've got a voice recording from a telephone call. They normally won't let you upload that. So that's why we like these to be done in writing. You submit all the information. I don't care if it's a package that thick. You give all that to the credit bureau and to the furnisher usually. And then if the credit bureau says, we're not reading all that, we're just going to say never late, well, then that's on them for making that mistake. So once notified by the CRA, furnisher has to do a couple things. So first, conduct an investigation, and then review all information, relevant information provided by the Consumer Reporting Agency, and then report the results of the investigation to the Consumer Reporting Agency. And if the investigation finds it's incomplete or inaccurate, that's why sometimes we talk in videos about, that's the whole standard, is the information incomplete or is it inaccurate? Then they have to report those results to all other consumer reporting agencies to which the person, that would be the furnisher, furnish the information and compile and maintain files on consumers' nationwide base. So in other words, they might get a dispute only from Equifax, but if they know they've sent this information, TransUnion and Experian and SageStream and Innovis and whoever else, they're supposed to notify them as well. And then if an item of information is found to be inaccurate or incomplete or cannot be verified after any reinvestigation, then they're supposed to do one of 3 things. modify the information, delete that item or the information, or permanently block the reporting of that information. And understand this opinion has no discussion, at least directly, of what a consumer reporting agency is supposed to do. So we don't know if he could have sued a CRA. I mean, based on the very much lacking evidence, I don't think he could have been successful against the CRA, but this is focused really just on the furnishers. And then it says a furnisher can choose to contact the consumer directly, but they don't have to do that. And so here's a question. Whether the act as amended creates private right of action for 1681 S.2b. And should they read the exclusion in the subsection A to also be there in B? And they say no. And you can read this. I mean, I'm going to skip over some of this. I mean, they just say we join the vast majority of courts to say there is a cause of action. And by the way, here's that sort of outlying case from Tennessee. So it says, all right, this tells us, since we know we can sue, well, what's the extent of the obligation? Because it does not define the word investigation, and it apparently gives the furnisher some flexibility. And they say, we know the investigation is meant to determine if the disputed information is incomplete or inaccurate. But then they say, and this is not necessarily true. This is sort of a quick discussion without much analysis. Mere incompleteness, however, is not enough. The incompleteness must be such as to make the furnished information misleading in a material sense. Well, we'll cover that in another video, exactly what that means. All right, so we agree generally with the Fourth Circuit, and this is a famous case called Johnson versus Mbna. We agree generally with the Fourth Circuit's observation and make little sense to conclude that in creating a system intended to give consumers a means of dispute and ultimately correct inaccurate information on the credit reports, Congress used the term investigation to include superficial, unreasonable inquiries by creditors. So what the Johnson case said is, look, you've got to do a thorough investigation. If a consumer disputes something, you better thoroughly investigate. You can't just go, well, we always report stuff accurately, so yeah, that's it. No, you got to do more than that. And they say this is an objective standard, and the burden of showing the investigation is unreasonable is on the plaintiff. And they say, well, look, there's a little bit more to it than that. So here's a recent case, and it involves a CRA, but they're going to sort of use that same standard here. They say, we recently considered what a plaintiff must show in order to carry his burden in a related context under the FCRA. We addressed a plaintiff suit against CRA, not a furnisher, upon being notified of the consumer dispute, and they say conduct a reasonable reinvestigation to determine whether the disputed information was inaccurate. And they say, we conclude, absent a showing of actual inaccuracy on a reinvestigation, plaintiff's claim against the CRA fails as a matter of law. In other words, to carry his burden, the plaintiff had to demonstrate some causal relationship between the CRA's alleged unreasonable investigation and the failure to discover inaccuracies. We hold plaintiffs suing furnishers must make the same showing. So what they're saying is, you can't just say there's inaccurate information, they did an investigation, they didn't fix it, so therefore I'm suing them. You have to show that had it been a reasonable investigation, they would have discovered that inaccuracy. And they say, here's a couple of reasons why. So a primary component of the reinvestigation requirement is the obligation to promptly notify a furnisher so that the furnisher can conduct an investigation. I'll say this. The CRA also has to conduct an independent investigation. Some courts, it's not real clear in their opinion, but the CRA has an independent obligation. They can't just simply say, well, we're going to accept whatever the furnisher tells us. If you've given enough information that the credit reporting agency can determine that the information is inaccurate, then they have an independent obligation to do that. And so this is talking about largely consists of triggering an investigation by the furnisher. That's true, but again, if we give enough information, let me give you an example. So I get sued by Portfolio Recovery. I deny owing Portfolio Recovery any money. And I do a dispute to the credit bureaus. And that's a really good idea when you've been sued. Well, the credit bureaus, they don't know. I mean, they can't figure that out. So they really are limited to just accepting what Portfolio Recovery says. So Portfolio Recovery is going to say, verify. Then I win my case. Judge says, John Watts does not owe Portfolio any money. Then I dispute again. And I send a copy of the lawsuit and a copy of my answer and a copy of the order where I win the case to the credit bureaus. And I say, look, a judge determined I won. Well, now the credit bureau, they still should reach out to Portfolio. Okay. And obviously Portfolio knows they sued me, I answered, and I won. But now the credit bureau, they can't just rely on Portfolio. They've got the information. And when we sue them on this, they go, well, maybe you forged the documents. We say, well, did you pick up the phone and call the court? Well, no. Did you call the collection lawyer to see? No. Did you do anything? No. Other than reach out to Portfolio. So I just don't want us to take this statement here that and reading too much into it, because that is not correct that, all they have to do or the primary thing they have to do is just notify the furnisher. No, if you give them enough information, they have to investigate it themselves. Then they say, given considerable overlap between their responsibility to reinvestigate, that's true, and a furnisher's duties, it would be inconsistent for the plaintiffs to bear a weightier burden in suits against the CRA than in suits against furniture. So they're saying, look, the standard is a reasonable investigation. And let's see here. We'll just come down. Just a reminder, the FCRA is intended to protect consumers against the compilation, dissemination of inaccurate information. And they say in their previous case, it's difficult to see how a plaintiff could prevail on claim of damages based on unreasonable investigation, disputed data, without a showing that the disputed information was in fact inaccurate, which that's correct. I mean, if you're suing saying the information's inaccurate, well, let me back it. If you're suing saying it was a poor investigation, you have to show that the information was inaccurate. I mean, that's the whole basis. It's incomplete or inaccurate. And they say, we want to emphasize it's a factual inaccuracy rather than the existence of disputed legal questions. So a disputed legal question would be, I've been sued and I say that because the debt buyer that sued me had filed bankruptcy, that they're judicially estopped from bringing a lawsuit against me because they didn't list this as an asset in their bankruptcy proceeding. Well, that's a legal question. And so the court here is saying we're not going to hold the CRAs or the furnishers to have to solve these legal questions. We're looking for factual inaccuracies. And this is a really important thing. And so I want to spend a little bit of time on it. What is a reasonable investigation may vary depending on the circumstances. For instance, a more limited investigation may be appropriate when the CRAs provide the furnisher with vague or cursory information about a consumer's dispute. And they say, statute is clear that the investigation is directed to the information provided by the CRA. A CRA's notice informs the furnisher of the, quote, nature of the consumer's challenge to the reported debt, and it is receipt of this notice that gives rise to the furnisher's obligation to conduct a reasonable investigation. And then they say, central inquiry, when assessing a consumer's claim, is whether the furnisher's procedures were reasonable in light of what it learned about the nature of the dispute from the description of the CRA's notice of dispute. So look, here's the take-home message from this. If we're just sort of making a general dispute, the account is inaccurate. Well, I mean, the furnisher doesn't have to do much other than just sort of give a cursory evaluation. Looks accurate to me. They report that back to the credit bureau. But if we give really specific information to the credit bureaus, so the March 2019 designation of me being 30 days is wrong because my due date, according to the statement, is March the 1st. And here's where my check cleared on March the 5th. March the 1st to 5th. It ain't 30 days. This is wrong. Very specific, very detailed. Well, that CRA's got a couple choices. It can communicate that very clearly to the furnisher And now the furnisher has a very specific obligation to go investigate the March 2019 and what the payment due date and when the check cleared, blah, blah, blah. Well, the CRA, that's what they should do. But what if they just say, never late? Well, the furnisher may not have much obligation. Now, if we kind of go around the back door and we send that dispute directly to the furnisher also, I'm not sure this court would agree in 2010, but I'll tell you, most judges would agree that when the furnisher gets notification from the CRA, they have to kind of look around and check their own files. And, hey, I got this certified letter from the consumer. Has all this info. They can't just ignore it. They can't just pretend what's in their computer system doesn't exist. So that's why we often, not always, there's some strategic reasons and times where it's not appropriate to send it to the furnisher, but usually we send the same dispute to the furnisher that we do to the CRA. All right. So if a CRA fails to provide all relevant information to a furnisher, remember I said there's two options. They can give all the information or they can just do a terrible job of that. It says the consumer has a private cause of action against CRA. So a lot of times when you're disputing and it doesn't get fixed and you gave enough information to the CRA, then you need to sue the CRA and the furnisher. Sometimes they're both liable. Sometimes the CRA will come in and go, hey, look, we gave all the information to the furnisher. There's no way we could have known this. The furnisher messed up. We're throwing them under the bus. Great. Give us that testimony and we'll let you out of the case and we'll hammer the furnisher. Sometimes furnisher says, hey, we didn't get the information from the CRA. We say, great. Give us that testimony, sworn testimony. We'll let you out and we'll hammer the CRA. Usually it makes sense to sue both of them. And they're saying, look, you can sue the CRA, but you can't sue the furnisher if the CRA didn't give proper information. So, with all that background, what are we looking at here? They say he failed to raise genuine issue material fact that the investigation was unreasonable, and he failed to show that there were any actual inaccuracies. And this is important. It says the consumer presented no evidence that the procedures employed by the furnisher to investigate the dispute were unreasonable. And this is odd. I don't know why. Indeed, the consumer neither sought discovery on nor produced any evidence whatsoever about the procedures that the furnisher used. That's odd. Maybe there's a strategic reason and this was a gamble. It just didn't pay off here. Okay. Normally you want to submit evidence. You want to go get testimony from whoever you've sued and even non-parties. And it says the only evidence on this point consists of the furnisher's uncontested affidavit detailing the procedures. And so that's all the court had in front of it. And so consumer loses. And then they say, look, we reject the furnisher's argument we should categorically exclude the consumer's affidavit, testimony, letters when deciding whether his claim should survive. And the furnisher was relying on that 1681 S2A1. And it says, for purposes of subparagraph A of section 1681 S2A1, furnisher's reasonable cause to believe furnished information is accurate, having specific knowledge other than solely allegations by the consumer. Now, it doesn't mean you just ignore all the letters. Like they never have to consider a letter. It says they don't have to consider the allegations of the consumer if that's all there is. But if there's additional support, so here's my bank statement showing I wasn't late. Here's a recorded phone call between me and the furnisher where they admitted that they did it wrong. Well, then they've got to look at that. And the court points out that that whole section that we looked at, that's the one you have no private cause of action, but that's not the same thing as the other subsection. The 1681 S2B does not mention a furnisher's reasonable cause to believe, nor did Congress otherwise add language about evidentiary rule. And so they say, we're not doing that. We will require the furnisher to consider even the plaintiff's allegations here. But here's the flip side. To say plaintiff's own allegations are not per se excluded does not excuse them from having to meet normal evidentiary requirements. And it says the affidavit letters are largely irrelevant and even accepted, they're not enough. It's not enough to win. So go back to the evidence. The consumer relies on solely on his own statements that there was inaccurate reporting, he had not paid his bills due and owing, and that he had had these discussions, and he urges us to infer that as a result, a reasonable investigation would have revealed their awareness of the inaccuracies. And talks about overcharges and conversations and letters he sent. And some of these letters were threatening litigation. And I think one was sent, to the furnisher's lawyer in one of those cases. And here's how the court summarizes it. It says, at most, it would have shown that Verizon, the furnisher, was aware the consumer disputed the claimed amount and that the dispute was in state court. And they basically say, so what? The court says, despite ample opportunity over 2 years, the consumer neither requested nor produced any evidence inconsistent with this information being accurate. And then they say, look, the furnisher only got cursory notices. And these are broad, non-specific statements. We take them in turn. So again, this is why we've got to be specific with the credit bureaus and hold their feet to the fire if the credit bureaus are not specific with the furnisher. And it's why we should also send the exact same information to the furnisher. So 2 reports said he had never been late. However, he admitted he stopped paying. So he was late. If you're late, you can't say it's inaccurate to say I was late. And then they say, nor for the same reason can 2 other reports which indicated he claimed to have paid the creditor before collection when he admits that he didn't do that. 5 reports say that he claims inaccurate information, which was not in the least bit specific as to what information was disputed. So a lot of credit repair, you'll see credit repair people, even credit repair lawyers, that will just put on their account is inaccurate. What does that mean? Now, the theory is that means they have to check every single piece of information, verify down to the last detail. And I understand that thought process, that that's what that means. That's not what the courts say. If you're just real generic, vague, then they kind of have to only give you a generic and vague investigation. They say finally several reports essentially said he disputed the account and was involved in litigation, which was true, and provided no guidance as to either the specific information that was disputed or the basis of the dispute. It says none of these reports alerted CBCS, remember that's like the person that's been outsourced to investigate for Verizon, to which of the allegedly erroneous charges underlying the dispute was inaccurate, nor did they evidence that a more searching inquiry may have been necessary. So here's an example of a case that says, merely verifying the account information is accurate as reported was reasonable given scant information received from the CRA. And then they say, we repeat, the investigation under 1681 S2B is geared to the information provided by the CRA to the furnisher. If the CRA fails in its obligation to provide all relevant information, then you sue the CRA, not the furnisher. Again, last time I'll do this caveat, probably. That's true, but also you should send the information directly to the furnisher so that they're without excuse. All right. And I think this is probably part of the reason why the plaintiff lost. Plaintiff's behavior in refusing to engage in discovery or provide any information about the reasonableness of the investigation cannot be a shortcut to trial on the merits. So they say the fact that you didn't do anything, you can't go, well, Judge, let me figure this out at trial. No, you should have done the work. You filed the lawsuit, do the work before trial. The fact that he told, or they put evidence they told Verizon, the furnisher, he disputed various bills does not itself raise a reasonable inference that the furnisher, through their outsourced company, conducted an unreasonable investigation or that the furnished information was not accurate. That evidence is not enough. In other words, go back to my example where Discover says I was late in January and I say, well, I called Discover and told them they were wrong. Okay, that doesn't prove anything. That's not enough. I got to actually show that the information is wrong. And then they say, independently, we agree the application of our holding, in this case, to conclude that the consumer was required to present evidence of actual inaccuracies and alternative investigation might have uncovered. He's not done so. And they say his affidavits and letters show he had some disagreements that went to state court litigation, and the furnisher doesn't dispute that. But he's not demonstrated any of his substantive disputes involve actual factual inaccuracies in his billing that a reasonable investigation could have detected. This ought to be a lesson. And for those of you that run credit repair agencies that are watching this, don't do these disputes where it's frankly a false dispute. I mean, like, if I know that I was late 6 months in 2018, I should not do a dispute where I say I was never late. That's not right. Now, I can look at that and say, all right, I was late during those months, but, in June, the first time I was late, Equifax says 30 days, Experian says 60 days, and TransUnion, or I can't remember which one I used, but anyway, they're all over the board on it. Well, that would be something because there's an inaccuracy there. But, if there's really no dispute about late payments, don't put the dispute is I was never late. If the dispute is over the date of last payment, if it's over the account balance, if it's over whether it was an installment or revolving account, make that specific dispute. I'm puzzled when I get these dispute letters and it has nothing to do with actual factual inaccuracies on the account. I just don't understand it. It doesn't allow you to sue. It puts no pressure on the CRA. It puts no pressure on the furnisher. We've got to identify the actual factual disputes here, and then we put pressure on the credit reporting agency and the furnisher. To the extent his argument reduces to the claim that any investigation that did not accept his allegations as accurate was by definition unreasonable, it fails. Yeah, that's right. So summary judgment was appropriate. Now, they just say on the FDCPA, this Verizon company does not count as a debt collector, and creditors collecting on their own accounts are generally excluded. There's a limited exception. Any creditor process collecting his own debts uses name other than his own name, which would indicate third persons collecting the debts. Sometimes it's called flat rating, where creditors attempt to intimidate debtors by creating the false impression third parties participate in debt collection process. So, give you an example. There's a hospital in Alabama, and it's actually that hospital or the hospital chain that sends the collection letters, but they give a totally different name on it. Okay, so it looks like, oh my goodness, I've been turned over to a third-party debt collector. It's really the hospital. Oh, we sue them. We will absolutely sue them. They are a debt collector. They come into court, they go, but we're really the creditor. Yeah, but you lied. You pretended to be a debt collector, so we're going to treat you like a debt collector. I sued Chase Bank one time over this because they had sort of their collection arm, and it had a name that had nothing to do with Chase. And so we sued them, and they went crazy over this. I'm like, you shouldn't lie about who you are, okay? And so here the consumer claims violated some provisions. Well, none of that matters unless they're a debt collector. And they said, allegedly deceptive name Verizon, Massachusetts. And they say that fails. And first of all, I mean, the courts give a little bit of leeway. Like, if they put the name in, generally that's good enough. In other words, if Verizon, Massachusetts is collecting, we can be pretty confident Verizon's not going to let some independent collection agency use the name Verizon, okay? So, and then they say, well, there's not enough evidence anyway. And they say, absent any evidence was collecting its own debts. We need not reach the argument that the name Verizon, Massachusetts would deceive people. And CBCS's communications, they go, nope, you didn't raise that. And so look, let's get to the footnotes here. State court grants summary judgment, so that's a problem. Let's see here. What I want to show you is this. All 12 reports indicate they responded, account information accurate as of date reported. And this is something that I think the court did not appreciate. Now, I'm not saying that this directly affected them, but we have to understand the psychology. And if we are doing things that will annoy a court or really call into question our credibility, that's just not very smart to do. So the consumer claims negative credit information prevented him from securing a $500,000 loan. Well, that could very well be. Having a negative item can lower us enough and we don't qualify for a loan. It says, although he's never earned more than $59,000 in a year, he alleges his failure to secure a loan prevented him from participating in international business deal, total contract value more than $200 million. That's pretty remarkable, okay? That one account prevented a guy that's never made more than 59 grand from being in this $200 million deal. He's variously estimated his lost profits at $500,000. Okay, that's what, 8-9 times what he's ever made. $8 million, $27.5 million, and $80 million. It's a little hard to believe that. I mean, it's not impossible, but you would have to put forth some strong evidence of this, that this Verizon account messed me up from getting into this deal, and it cost me $80 million. Not in revenue, but in lost profits. That's pretty amazing. So this is just kind of a reminder here. You can notify furnishers of disputes directly, but there's no private cause of action. And the consumer's not asserted he complied with it. A notice of dispute information provided directly to the consumer does not trigger obligation. And then they say, we need not address how, if at all, a direct notification would impact a furnisher's later investigation. Well, I'll tell you, and I feel very confident about this, and I think most courts agree, that if you do it directly to the furnisher and then they get notified by the CRA, they have to use that information that you provide. In other words, they can't just close their eyes and go, we're going to pretend we didn't get that. No, they've got to look at it. And so that's why it's a good thing to do. So I think that's probably all of this that I want to reference. I know it's been a very long video, so if you're still with me, thank you for staying with me this long. I hope it was helpful. We'll put the link as we always do. But with this one, since it has the actual case site here, that makes it easy. You can just Google that, go in Google Scholar and put it in there, and that'll be very easy to find. So thanks again for watching this video, and I will catch you guys in the next one. All right, bye-bye.